The new law on non-arm's length expenditure has finally been passed by Parliament. Today, I'm speaking to Tracey Scotchbrook, the head of policy and advocacy at the SMSF Association, to understand what this means for SMSF practitioners and trustees. Good afternoon, Tracey. Thank you so much for joining me today.
Hi, Todd. It's great to speak with you.
Tracey, firstly, what's the association's view on how the NALE law has turned out? Do you think it meets expectations, or does it leave a lot to be desired there?
Yeah, look, a great question. And I think I'll start with a football analogy in that this is really a game of two halves. And the two halves I'm talking about here are the operation of the NALE rules for general fund expenses versus specific fund expenses. So I'll start with some good news, and that is that we have a solution for the general fund expenses, which were the focus of the amendments contained in the bill, which was the Treasury Laws Amendment Support for Small Business and Charities Bill for those that are playing along at home. Now, that bill passed both houses of Parliament in the last week of June and received royal assent on the last business day of the financial year. So it really was a last-minute rush and push to get those measures legislated and operative before the end of the financial year. That timing is really important because the ATO's practical compliance guidelines, that's PCG 2020/5, was only intended as a temporary solution whilst we're getting a legislative fix put in place, and that expired on the 30th of June. So the passing of this bill provides really important certainty for practitioners and trustees alike. If we look at the measures themselves, we've certainly landed in a much better place when we consider that the original drafting of the NALE rules for a general fund expense that was not at arm's length had the effect of tainting all of the SMSF's income as NALE. So that's really quite a disproportionate outcome. When we look at the legislative solution that Treasury had originally proposed to try and fix this problem up, they put forward a 5 times the shortfall approach. And so what we're talking about here is looking at the amount that's either not been charged to the fund or undercharged to the fund, multiplying that by 5, and that gives us our non-arm's length income amount that would be taxed at the top marginal tax rate, which is 45%. So as a result of some advocacy and engagement with Treasury, of which there was quite a lot that happened in the background over quite a period of time, this 5 times approach resulted in the 2 times approach that has now been legislated. So we look at where we started, to what was proposed as a remedy, to where we've landed. I think we've landed in a much better place when it comes to general fund expenses. Unfortunately, the story is not so good when it comes to specific fund expenses, and we still need a remedy here, and that needs to be through a legislative amendment to provide something that's more proportionate and a bit more workable.
Okay, and as you know, the law came into effect from the 1st of July of this year, of this financial year, but it applies retrospectively from the 1st of July 2018. Now, do you think that this retroactive application could pose any problems for SMSF trustees? Is that something that you see?
So fortunately, this is one of those cases where retrospectivity is really important and was needed to provide certainty. They provide an important remedy to ensure that the law operates as intended. So we had those original non-arm's length expenditure rules came into force from 1 July 2018. So it was really important that the fix that was put in place here aligned with that start date, because there really were some egregious outcomes that were sort of flowing from this. One example that we saw was we had an accounting fee that was undercharged by $500 that could actually result in the whole of the fund's income being taxed as non-arm's length income. So I think, yeah, retrospectivity here is actually really positive and a really good outcome.
And I know you mentioned before, and you've mentioned previously in some of the other presentations that the SMSF Association has done, that this law doesn't address specific expenses related to the fund or actually interactions between, say, capital gains tax provisions. Are you expecting to see a remedy coming up in the near future to address some of those issues, or is that still in the works and uncertain?
Yeah, look, I think there's still some uncertainty here. There's still more work that needs to be done. Our messaging to Treasury has been that it's fantastic that we've got the solution for the general fund expenses, but the work is only part done. I talked earlier about that two halves, and now this is the second half of the problem that we do need to look at, because there's some really quite egregious outcomes arising here when it comes to specific fund expenses, and there is a very strong element of retrospectivity to how the tax operates. As you mentioned, we've also got problems how the capital gains tax method interacts with the method for the calculation of a fund's taxable income, including the NALE element of that calculation methodology. So yeah, we need a legislative solution to address each of these issues. So where a specific fund expense is undercharged or not charged to the fund, this has the effect of tainting the asset as well as the future capital gains as non-arm's length income, as well as the income that's derived from the asset. So if you've got a property, then it's the leasing income's tainted forever. And to put some context around it, what do I mean by specific fund expenses? These essentially are expenses that relate to a specific asset in the fund. These could be capital improvements to an asset, maybe undercharging of LRBA interest, or indeed it could also relate to the original acquisition of the asset if that is not on arm's length. We're hearing a range of different cases when we're talking to members and other stakeholders. And one recent example that was highlighted to us was a fund that held a property for 10 years, but due to a mistake, they underpaid just 2 months worth of interest in relation to a related party LRBA. So it was a mistake. They got something a little bit wrong, but as soon as they became aware of it, which unfortunately was in the July of the following financial year, they rectified that as soon as possible. So the fund has been put on the right footing, so to speak. Unfortunately, we've got a situation where the NALE rules come into play, and the capital gain on that property is tainted forever as non-arm's length income, as is the leasing income from that property going forward. When we look at the ATO Law Companion ruling here, which is LCR 2021/2, for those who want to have a look at that, there is an example in there of Trang the plumber, and this has been quite a controversial example, but it highlights the sorts of issues that can come out to play. And in this particular example, the ATO talked to the plumber who conducts some bathroom renovations to their rental property, but they don't charge for their plumbing services. So they've charged for all the goods, but they just haven't charged for their time here. And this is considered to not be arm's length and will taint the rental income from the property. It'll taint the capital gains on the future sale of the property. So this is where we have the retrospectivity. When you've got an asset that's been held over a period of time, at a more future date, we have something that occurs that is non-arm's length income, or non-arm's length expenditure, I should say, but we have the impact of tainting the whole of that capital gain. So we've got no proportionality, no concept of materiality, and there's no ability for the trustees to rectify if we, think back to the LRBA example. So there's some quite serious consequences. So yeah, we need a solution, and we need one quickly.
Are there any other areas that SMSF trustees should be aware of with this new law? For example, I know you've mentioned the calculation of exempt current pension income. So I was just wondering what other things that trustees might need to be aware of with the passing of this law?
Yeah, so you mentioned ECPI there, and I think that's a really good reminder for practitioners and to make sure they do engage with their clients who are in the retirement phase, because often they think, oh, everything's tax-free, it doesn't matter. It really does matter when it comes to NALE. So anytime we've got non-arm's length income or expenditure, where that non-arm's length income will arise, it's not going to be washed away as exempt current pension income. It is taxable, and it's taxable at the full 45%. So we need to make sure that they're properly recognising and the fund paying for their fund expenses. They need to be on arm's length. They need to be recognising all of those expenses, because we could have a situation of a fund that is in pension phase. If we, think back to that property example, we had an underpayment of 2 months of LIBA payments due to a mistake. That could mean that the capital gain on the sale of that property and all the leasing income is not tax-free under the ECPI rules. They will be taxable at the full 45%. So I think that's going to be an important area of focus, and it really highlights the importance of having really good record keeping and having really good engaged trustees, that they are checking in with you before they're doing things to make sure that we don't end up with a Trang the plumber scenario, which we've got no ability to rectify the way the law currently operates.
As I mentioned previously, Tracey is the head of policy and advocacy at the SMSF Association. The association has been working diligently to advance the interests of the SMSF sector, especially regarding the proposed Division 296 tax on superannuation balances above 3 million of late. Tracey, thank you so much once again for spending some time with me to discuss the NALE law.
No problem, Todd. Thanks for having me.